Well, we're into the hard stuff this week, dismissals. It's a tricky issue and something that employers and employees find quite stressful. So I think it's an area we really need to examine in some detail so we know exactly where the law stands and also we know who to go to for advice on those issues. Don Tepper, the CEO of the Real Estate Employers Federation, is very experienced in this area. Don, what are some of the reasons for termination of employment that you see in real estate?
Oh, no, not only in real estate, Emma, but some reasons for termination of employment include misconduct or poor performance on behalf of an employee, or a position may become redundant, or even serious misconduct sometimes occurs, or there's abandonment of employment, where an employee just walks out and for some reason doesn't come back. Or the employee resigns, which of course is quite common in real estate, or there may be long-term illness or injury. So there are some of the reasons, why a dismissal occurs.
What do you see as the most common reason for a dismissal by an employer?
An employer-instigated dismissal normally revolves around either misconduct or poor performance. These are very common issues.
Yeah. What is a remedy an employee can seek if they think they haven't been fairly dismissed and for particularly poor performance or misconduct?
Okay, if an employee is dismissed and they think it's unfair, or they can take out an unfair dismissal claim with Fair Work Australia. This type of application can only be made by an employee with 12 months service.
Okay, that's a pretty important thing to know, isn't it? That
it
12
is.
Months, yeah.
Or 6 months. Now it's 12 months if it's a small business.
Okay, yeah.
That is, the employer employs less than 15 employees.
So that'd be pretty common in real estate?
Pretty common in real estate, or where the employer employs 15 or more employees, and a new employee cannot make an unfair dismissal claim during the first 6 months.
What can an employer do as a bit of a defence against unfair dismissal claims? I mean, it's obviously an area you don't really want to get into as an employer if you can avoid it. So it's the risk management around that.
No, but unfortunately, sooner or later, most employers do find that they need to talk to an employee, either about their conduct or about their performance. And the law recognises a certain procedure the employer must take. There are certain elements, if you like, that the employer must cover. If the employer doesn't cover those elements, well then Fair Work Australia can classify the dismissal as being unfair, unreasonable or unjust. So the procedure for an employer to follow, if they wish to talk to an employee either about undesirable conduct or poor performance, is first of all, the first element is they must advise that employee that they're entitled to have a support person with them when the employer talks to them.
Yeah.
Now this is entirely the employee's choice as to whether or not they do want a support person, and it's also the employee's choice as to who that person is.
Is there some restriction on who that person can be, John?
No, that's up to the employee. They can choose anybody they like.
Yeah.
A friend, a work colleague, a lawyer, a union official. It's entirely up to the employee who they choose as a support person. Secondly, if the employer does dismiss an employee for conduct or poor performance, the reason for the dismissal must be valid. Now, what is a valid reason can be a whole session in itself. So if an employer is in doubt as to whether or not their reason is valid, they should seek advice. At a meeting with the employer should put its allegations or its complaints clearly to the employee, and what is important, the employee must be given the opportunity to respond or given the opportunity to defend themselves. This is natural justice. If you have a complaint, if the employer has a complaint against the employee must be given the opportunity to defend themselves. The employer then must outline their expectations as to future behaviour and future performance. And there must be clarity around this. The employee must be very clear on what the employer expects of them. And it's best to put this in writing.
Yeah. I suppose that sort of removes any interpretation problems too, doesn't it?
That's right. That's
Writing
exactly right. And then the employer must allow the employee sufficient time or a reasonable amount of time in which to improve. The employer sets a review date 3, 4, 5 weeks down the track, and also gives a letter of warning. Now, something that most employers seem to overlook, a warning is actually saying something like, if your performance or your conduct does not improve, your employment may be terminated.
Yeah, so being that blunt.
Yes, that's the actual warning. In other words, if the employer does terminate the employee's employment, it must not come as a surprise. So they must be warned that their job is in jeopardy if their conduct or performance does not improve.
Just sort of on that in writing stuff that we're talking about, Don, as an employer, would you also recommend that people take notes about what happened at the meeting?
Absolutely,
Yeah,
yes.
and it's got to go in that HR file, doesn't it?
Again, my association has all these procedures outlined in writing. It has template letters, warning letters and so forth that the employer can use and take advantage of. And it also outlines the procedure in far greater detail than I have done today. Yeah.
While we're on the difficult topic of unfair dismissals, can you tell me a bit about probation? Because a lot of people sort of have assumptions about probation periods, but often I find they're quite outdated. So what's the current law on probation, Don?
The first thing I would like to say on probation is to say to every employer, stop telling the employee and stop putting in your letters of offer that you are on probation for 3 months. This is very, very common in real estate, and it's also very common in other industries where an employee was advised when they were hired they'd be on probation for 3 months. Now this can be, today under the new law, this can be misleading, and we've already covered it to a certain extent by talking about those 6 and 12 months that I was talking about before. The Fair Work Act actually does not use the word probation like the old acts used to.
It's quite a different terminology, isn't it?
Yes, it's what's referred to as the minimum period of employment.
Okay.
So a new employee must serve a minimum period of employment before they are allowed to access an unfair dismissal remedy. And this gets back to the 6 and 12 months we were talking about before. A new employee where the employer employs less than 15 employees must serve a minimum period of employment of 12 months before they can access an unfair dismissal claim. And with an employer with 15 or more employees, a new employee must serve 6 months before they can take out an unfair dismissal remedy. Now, the effect of this, even though the Act doesn't use the word probation, the effect of this, a new employee is automatically by law on probation for either 6 months or 12 months.
Okay.
And a new employee, when they're hired, should be made aware of that. So there's no misunderstanding. So you can see if you say to an employee, like we used to in the past, you'll be on probation for 3 months, could be misleading. You know, the employee comes to the end of 3 months and say, oh yeah, I'm not on probation anymore. When in fact they are. Either for another 3 months or another 9 months.
Well, thanks for clarifying that in relation to probation, Don, and also thanks very much for your counsel on unfair dismissals. It can be a tricky issue, and I think what you've highlighted today is the importance of engaging a specialist as an employer to check that all those checks and balances are there at the end of a difficult process. And indeed, the Real Estate Employers Federation is one of those specialists that can help you with that advice. So we look forward to seeing you in the next IR session, Don. Thanks very much.
Thank you, Emma.